We're live.
Good afternoon. It's the House Judiciary Committee, and this is a voting session on the 5th of April, 2022. We're going to go ahead and we've got a relatively brief docket. It's going to be probably the last of the brief dockets, I think, as we get closer to the end of session. I'm going to actually, I think, start from the opposite end. We have two bills, House Bill 529 and House Bill 529 and Senate Bill 559 that have to deal with the issue of supported decision-making. The idea would be to conform the House bill to what the Senate passed. This is one of Holly's bills. Holly, can you tell us what the bill would do as amended into the Senate version?
Sure. So just a little bit of background. The supported decision-making is the process by which an adult with or without a supported decision-making agreement would utilize support from a series of relationships. The Senate took Senate Bill 559 and specified that an agreement, a supported decision-making agreement, will not supersede the authority of a power of attorney or an advance directive. They added in a requirement that makes certain things applicable to the actual agreement, including the agreement must be signed and delivered to anyone with the authority under a power of attorney or an advance directive or a trust. And it adds that a person against whom the person seeking a supported decision-making agreement has obtained a protective order may not be on the list of people who can be a supporter for the person. And it also prohibits an agreement from authorizing a supporter to enforce decisions outside the presence of the adult. And then there's some technical amendments.
Move the amendment.
All right, so this would be moving the amendment on House Bill 529. Is there a second to do that?
Second.
All right, moved and seconded. Any discussion? Again, this would be to conform the House bill to the Senate bill as Holly just described. So if we want to have discussion, why don't we adopt the amendments to conform, and then we can just talk about the Senate bill. Is that all right? There we go. Okay. All in favor of the conforming amendments to Senate Bill 559, please raise your hands. Shoemaker, Shetty, Munoz, Howell, Moon, Grammer, McComas, Jones, Lopez, Williams, Anderson, Cham, Cardin, Tolles, Arakan, Cox, Crutchfield, Bartlett. Anybody opposed? I don't think I saw anybody opposed. All right. It's a motion for a favorable as amended on House Bill 529. Now we can do discussion. So Delegate Bartlett, if you have your question now, that's fine.
Thank you. Yes, I do have a question, and I was trying to find the answer myself, but I didn't find it fast enough. And Holly, you could probably find it faster. I got the part about it can't supersede a power of attorney, but is a power, must one have a power, must one also be the designee on a power of attorney in order to so is a power of attorney required in order to have a supported decision-making agreement as well?
No, it's completely different.
Right.
You do have to get permission, but no, like you have to let your power of attorney know, which is where that superseding comes in, but it's not a requirement. You can have a supported decision-making agreement and supporters without having a power of attorney.
Okay, great. And so if one person is on the power of attorney and someone else is on the supported decision-making, then essentially the supported decision-making is a nothing burger?
Not as I perceive it in the bill, because that supporter can help the adult. So I think they would all work kind of in unison as the supporter being the person. It's not just making decisions, it's helping the adult understand the decisions, utilizing the decisions, understanding the ramifications of certain decisions. So I think that supporter takes an added role to the power of attorney, doesn't overstep it, so to speak.
Okay. All right. So now I understand the amendment a little bit better. So basically, the decision the supported decision-making agreement, it is literally still what it was in the beginning, and that is a support. Whereas a power of attorney actually has all control if in effect.
Yes,
that
that's,
a true
that's
statement?
correct. And I mean, I have the language right here. It says basically the supporter is helping to increase the adult self-determination, preventing the need from an appointment of a substitute decision maker. For example, if there's not an attorney, a power of attorney already present, or limit or terminate the use. So I think it's just adding another support system.
Okay, great. Thank you.
That's certainly my impression as well. So it's meant to be another way forward for people who may have disabilities to be able to go forward. All right. We are on the bill as amended. This is House Bill 529, Delegate Pena-Melnick's bill on supported decision-making. It's been amended to conform it to the Senate version, and we're going to do a roll call. The Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Yes.
Carden,
Yes.
Conaway is excused, Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher, Delegate Juanita Fisher, 529. I'm not sure if she can hear me. Guessing she can't. We'll come back to her. Delegate Grammer,
Yes.
Howell,
Yes.
Jones, Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Sorry, yes, Mr. Chair.
all right, Juanita Fisher votes yes. McComas.
Yes.
Okay. Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Poles,
Yes.
Williams.
Yes.
That's 20. All right, so now the Senate cross-file is 559, Senate Bill 559. We've conformed the House bill to look like the Senate bill.
Move favorable.
There's a motion for a favorable. Is there a second?
Second.
All right. Any discussion about this? Seeing none, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell. Howell is nodding her head yes, is muted. But okay, we'll take that as a yes. Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Sponsor issue. Yes.
Cham,
Yes.
Bowles,
Yeah.
Williams.
Yes.
All right, that's 20.
Okay, Hal verbally says yes, sorry.
All right. Thank you very much. All right, we're going to do, moving my way up from the bottom of the list, I guess. This is Senate Bill 704. We heard it today a lot, and House Bill 1011. We heard it a while ago. This is extending effectively the electronic home monitoring funding. There was $5 million put in the budget last year from federal funds. It has not been completely spent yet. So the idea would be to allow this program to continue into the next fiscal year so that they can spend that money and hopefully get a work group going so that we can discuss this issue and figure out what to do when the funding ends. So to that end, there is an amendment on both bills. It removes, I think it's on both bills. Claire, can you help me?
Yeah, well, the House bill, we're just conforming it to the Senate bill. And the Senate bill, the only change is that we're bringing in the text from the uncodified session laws from last year and striking two of the industry members of the work group.
So it would strike the people from the electronic home monitoring industry from the work group that seeks to determine how to pay for electronic home monitoring going forward. And how that program would work. So that's the amendment, and we'll do it, that amendment to Senate Bill 704, and then conform 1011 to do that. So could I have a motion on the amendment for 704?
Move the amendment.
Is there a second?
Second.
Second.
Yes, thank you. All right, so we're on the amendment. Does anybody have any questions or concerns about the amendment? Seeing none, all in favor of the amendment, please raise your hands. McComas, Shetty, Howell, Moon, Williams, Bartlett, Tolles, Carden, Cham, Anderson, Crutchfield, Cox, Fisher, Lopez, and I think that, and Jones and Davis. Anybody opposed? Shoemaker. All right. We're on the bill, Senate Bill 704 as amended.
Move favorable.
Motion
Second.
favorable in a second. All right. Any further questions, discussion on the bill as amended? Delegate McComas. You're muted. You're still muted.
On the comments.
There was like 11 votes against the bill in the Senate, and I don't understand why. Does anybody know why?
Again,
Because it would be, they're against what we've just done. So I'm kind of curious to know if we have any feedback as to what it was.
Johnny Carson used to do this thing where he would listen to an envelope.
Harnett.
It would
Carnac,
tell
the
him.
magnificent.
It would tell
Yes.
him, I mean, I know this is obscure for many members of the community, but still, and this case, Delegate McComas, it's empty. I got nothing for you. I don't know what to tell you. I don't know what to tell you. I got nothing.
Well, Mr. Chairman,
I've been working on that routine for at least 5 minutes.
I love that routine, by the way. But in any event, I mean, there's no state money involved. This is to exhaust federal money that's already been allocated for this program.
Correct.
Okay.
Got to work in a Johnny Carson reference. It's obscure.
Love Carson.
Okay. Letterman should have followed him. Anyway, I'm not sure. Anyway, fine. Jay Leno fans are immediately voting for other people. All right. Are there questions, further questions or statements or criticisms of NBC programming decisions? All right. Seeing none, we're on the bill as amended, Senate Bill 704. The Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Eric Han,
Yes.
Yes.
Bartlett. Oh my God. Carden,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Brammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
All right, that's 20. The chair would make a motion that we adopt the amendments conforming House Bill 1011 to Senate Bill 704. Does anybody have an objection to that?
No.
All right, does anybody have an objection that says that the vote for Senate Bill 704 would then be the vote for House Bill 1011?
No objection.
Without objection, so ordered. We are going to keep moving then. Now we'll go to housing bills. These are where I thought they were, except they're they're over here. Helps to be organized. All right. So Senate Bill 563. I don't believe we've talked about them here in the voting session yet. So if people have questions or concerns, we can certainly take them up. But Holly, there are amendments to Senate Bill 563, and they are number 273928. And there is a reprint of the bill that is between pages 12 and 20 in your packet. Holly, would you tell us what the amendments to Senate Bill 563 would do?
Sure. So our amendments establish that the status of a rental property as an affected property under lead-based paint abatement laws may, instead of may not, which was the statutory standard before, be an issue of a fact at trial. And then the amendments also prohibit the court from entering a judgment in favor of a landlord who fails to prove that a property is compliant or exempt from compliance from certain local license requirements. That's what the JUD amendments do. Did you want me to explain the Senate amendments as it came over?
Yes, please.
Okay, and so the amendments that were already done to 563 as the Senate passed it, the Senate struck language that authorized the district court to award certain costs and expenses related to an action to repossess for certain breach of lease if they were made in bad faith or without substantial justification. The Senate specified that the bill does not apply to a tenant holding over action or a breach of lease where the landlord can show that the action by the tenant caused the licensing authority to suspend, revoke, or refuse to grant or review the rental license agreement and requires the landlord to provide the tenant a certain notice. The amendments by the Senate also alter the manner that a landlord may demonstrate that a property is licensed, including a landlord can show an electronic license, and it removes an exception for a temporary or provisional license. And then there are also some technical amendments.
All right, a fair amount to unpack there. Does anybody have any questions with regard to the posture of the bills? Delegate McComas.
Thank you, Mr. Chair. Quick question. The Maryland Realtors were against the Senate bill initially. And let's see who else was. I'm just scrolling down because we have a lot of private nonprofits. Okay, and then there was a gentleman, Nathan Rayar. I don't know who he was. He was unfavorable. But I think I'm concerned about the realtors because there are a lot of folks that are living on fixed incomes that use rental property to supplement their income. And actually, I had a gentleman talk to me who had an apartment in Bel Air, and he didn't know anything about having it tested for lead paint or anything. And it was kind of sad because, you know, he was a widower and it was just kind of and so he decided he wasn't going to rent it. So he's losing money because he just, in other words, lead paint really is an issue if you have little children, and it's I don't know. Anyway, I just kind of wonder what the realtors think of it now. I know it was voted unanimously out of the Senate, but you know how they are. We don't know where their little brains are from time to time.
Well, I don't have another envelope. I will say that I do remember receiving an email, I believe, from the realtors after there were further discussions on this legislation, and I'll look really quickly again for it. But I believe that they had been talking to the sponsor and had worked out their concerns, and those concerns were addressed when it came over. I think there were other concerns expressed, and I believe that Delegate Cardin had expressed some of those concerns that were independent from those of the realtors. I think the realtors' concerns were addressed. I think that Delegate Cardin's concerns were not directly addressed. And Delegate Cardin's got his hand up, so I'll let him talk about it.
Thank you, Mr. Chair. Can I just ask a quick question to Holly first, and then I'll tell you.
Go ahead.
So one of the amendments in the Senate version was that a holdover cannot, the-
Do you want me, it's on page, and this goes back to what Chair was saying with the realtors, it's page 5 of your reprint. And I think it's going to be, what you're talking about, Delegate Cardin, is subsection A, paragraph 2.
right.
And
And-
that was one of the provisions that the realtors wanted, so that if the tenant caused damage to the property, the landlord would still have recourse.
Right. So my question is, if you have a tenant holdover that, and the landlord is attempting to remove that tenant, does the landlord lose his ability to, if there's a code violation in another unit in the development? In other words, if there's another unit that has a violation, and that's the reason for the licensure revocation, it's not about the holdover. Does then the landlord have the inability to try and remove the holdover? Am I asking the question correctly? I mean, does anybody else like understand the question? Like
I believe it's per residential rental property. So in that situation, if it's another person in the building, I don't think that would be applicable. But I mean, that's as I'm reading 8406.
Right. So I'm just trying to figure out. So because you've one license, and you've got multiple residents in multiple units. So I understand that we worked out the issue for that. If the one guy is the cause of it all, he can't then try and, if he's the reason for it, he doesn't have the standing to be able to stop the landlord from doing what the landlord wants to. But what if it's another unit that's causing the licensure issue? Does that mean that the license holder, the landlord, is disqualified from trying to manage all the properties? That's what I'm trying to figure out.
I would say that it's just that one property, the entire building. Like he wouldn't be disqualified from the entire building, but I'm happy to look into it and guarantee that.
Look, I'll make it clear that I like what we're trying to do. I just wonder if we're, and maybe Delegate Williams, I know you and I have already discussed this a little bit before, but I wonder if there's unintended consequences. That's one of my thing. Yes, you should have a license to be able to do these things. The question is, if your license is not valid, not having nothing to do with the property that you're focused on, but having to do with a different unit, the question is that fair to everybody? Because everybody, then the landlord could be stopped from helping or dealing with all these other units simply because of this one person who is claiming, who's causing the licensure to be in jeopardy. And I'm getting I guess lots of people are listening because I'm getting all kinds of buzzes on my phone. I'm not really, I'm just wondering if I want to make sure we're doing the right thing here by requiring the licensure, and we're not causing other unit tenants to possibly be put in harm's way. And that's really the issue for me. Again, maybe we figured it all out. Maybe this is the right way to go. And I'm just kind of asking that question.
All right, there are many other people who want to talk. And so let me take some more questions here, and then we'll go from there. Delegate Grammer, then Bartlett, then Williams, then McComas.
Thank you, Mr. Chair. So I believe we heard this or a similar bill last year, and I have the same reservations that I heard last year. And I think that why everyone's getting a creeping feeling that Delegate Cardin was speaking about is that if we're to agree that a property owner shouldn't be able to, they should have proper licensure to rent the property, that should apply at the time of rental and throughout the actual rental, we shouldn't have this wonky system, which we do have, where we allow bad landlords to operate illegally, and we accept that's the case until it's time to repossess. Now, we can't repossess without a proper license, which it creates all kind of wonky situations. So here's my question. To which actions to repossess does this apply? Is this all actions to repossess, or is this just on a violation of lease because of failure to pay rent? What, can someone answer that for me?
I mean, I can answer. It's failure to pay, breach of lease, and holding over. The lead is explicitly an 8401. That's where you see that language, but it's 8401, 8401, 8402, and 8402.1.
So the holding over cases, that's what I'm concerned about. Which particular holding over cases does this apply to?
It's going to be, as I see it, all the holding over in 8402.
Is that just failure to pay rent, or is that any tenant who is there who holds over?
As I understand, it's any tenant that's holding over.
So there are certain situations where a person can be, I have an email in front of me here today. A party was going to sell a property. They went to do one of the checks prior to sale. They totally brought the property up to code. They redid the interior. We're going to check this because we're going to sale. And they found that someone had pulled up with a moving van and they had just moved in. And when they asked this person to procure the documentation that gave them legal right to the property, they gave them a fake lease. They said, I had given my landlord a bunch of money. The address on the lease was the address of a Walmart. And now the party selling the property cannot evict that person because of state law. Is that considered a holdover? In that particular example, would that person that was there illegally, could they hold over in this situation?
Delegate, I'd have to check, but yes, I believe so. But let me check under 402. And like I said, this was House Bill 174 that already passed through. So let me I actually have Auntie and I'm just double checking. So yes, but I believe it applies to all holding over cases.
Yeah. So while you're checking that, and I appreciate that, but just to be clear here, this is a situation in my district where someone is trying to legitimately sell a property, bring it up to code, do the proper evaluations. They're trying to sell it to another party who's looking to buy it as a owner occupant. They're doing the check. Someone just moves in illegally. And that person who has moved in illegally could evoke this section of law and say, of course, this is for sale property. But if this were to be rented, a person who was in a property illegally, which happens very frequently, could say, look, I need you to procure your license to rent a property. And these kind of wonky scenarios pop up all the time. So, I'll stop here and I'll just say, I lament the fact that we don't apply these conditions. If we're going to have these licensure frameworks in place, we should apply them properly at the beginning. We should apply them throughout the actual rental of a property, because we have spiraling nuisance issues. And it's just a shame that when we have these nuisance problems, we can't adjudicate this properly anytime during the rental. And now when we try and evict someone, we're going to create these ridiculous scenarios. But I appreciate the time, Mr. Chair.
Delegate Bartlett, then Williams, then McComas. Bartlett.
Thank you, Mr. Chair. I got a little confused, but I think I still understand the bill. I thought that the purpose of the bill was to not allow landlords who are not licensed or do not hold a proper license to rent, the inability to evict tenants. Is that part true? And I guess that's a Holly question.
Can you say it one more time, Delegate? Sorry.
I thought that the original intent of the bill is that it's almost an issue of standing, where if you are a landlord and you are unlicensed, that you are not allowed to use the court's eviction procedures.
Yes, and that was a
Okay.
case, a Court of Appeals case where this legislation originated from. It's McDaniel versus Baranowski. It was a 2011 Court of Appeals that held a landlord is not entitled to use statutory remedies upon a tenant's failure to pay if the landlord's not complied with applicable residential licensing requirements.
Okay, so instead of standing, I guess it would go in the clean hands equity type of consideration. But let me ask you the question. There was some discussion about subsidized housing being exempt from this. I don't see it in the bill. I tried to do an eyeball check on it and I did see it. That amendment's not here, right?
No.
Okay, thanks.
And then I just wanted to clarify back to Delegate Grammer too. I've got Matt that is explaining. I think Delegate Grammer, yours would fall under wrongful detainer, which is not addressed under this bill. So holding over is there's the right to possess, but it has ended versus I think Delegate Grammer, the wrongful detainers, there's no right of possession. So this is not addressed in this bill. That wrongful detainers under 14-132 of the real property article.
Delegate Williams, then Delegate McComas.
Thank you, Mr. Chair. I think Holly kind of addressed, I guess, the comment I was going to make about the wrongful detainer portion, because that I don't even think is applicable to this bill. I guess I wanted to kind of go back to Delegate Cardin's comment, and I guess I'm just trying to figure out, I guess I was getting a little confused with the question that you were asking, Delegate Cardin. I just want to make sure I'm understanding what the concern is. If you're saying because there's two types of rental licenses. I can have a rental license for a single family home. I can have a rental license for a multi-family dwelling. So I'm assuming you're talking about the license for, say, a multi-family dwelling.
Yes.
Okay. And so I guess I'm just trying to figure out what type of violation in one unit would cause me not to be able to evict the person in a second unit. I guess that's what I was trying to figure out.
May I, Mr. Chairman? My thought is that that's the whole point of the bill, is that you jeopardize your license. And once you jeopardize your license, the landlord loses his interest in the property, his ability to do what he wants to do. I mean, isn't that in fact what's happening here? And so,
yeah, but usually the license is jeopardized if the building doesn't meet code, or there's some type of, I don't even know, like tax liens or something, encumbrances against the property.
right, but
that would affect the
well,
building as a whole,
what if
not
what if the allegations from the one is in fact that there is a code violation, and so they then jeopardize the license for everybody, but they're a holdover. They're the ones.
Yeah, but then now this goes back to, I guess, a greater public policy question. If there's a code violation, don't we want that landlord to take care of that code violation? And this would incentivize the landlord to do that.
Right, but well, I would agree with that. I mean, from a policy perspective, I agree. I'm more concerned about what the implications might be to the residents, the other residents in that facility, or in that one unit, in that one building that has multiple units. And you have, if you have multiple units under one license, I just am worried that you may impede on one person's property rights, one of the residents' property rights, because of another resident's allegations that are going to, I mean, it's just it's the question. I'm not.
Right, I guess well, really you're impeding on the landlord's ability to evict tenant number 2 because of something going on in unit number 1.
Which is his right. I mean, as the owner, but
Yeah, I mean, I guess I'm okay with the bill as written and as amended. I tried to reach out to some folks I know with the realtors. I think they're okay with the bill as amended. I think, the only person that this might negatively affect, John, in your scenario is the landlord not being able to evict tenant number 2 if there's a violation in unit number 1. But I think from a public policy standpoint, like I said, I think we want the landlord to correct whatever violation is going on for habitability reasons and et cetera. So.
Sure. And I'll just say what I told you before in private, which was that, you have somebody in theory who is a tenant holdover who doesn't technically have any property rights, who has managed to take away the rights of the landlord to be able to do what he's entitled to by contract and by law. So you would have somebody without property rights impeding on somebody's property rights who does have it.
By claiming a code violation. But yeah, but then the landlord can easily clear that up as saying the violation doesn't exist and then proceed with removing the tenant.
Or to fix it, right? Or to fix it, right? But everybody but he loses his property rights to all 400 other units because of one, because of potentially one allegation. I'm looking at it from a public policy standpoint. I understand that we obviously want to protect these tenants, and that's right. But we also have to protect contract law. So I'm just kind of looking at both sides.
All right, thanks.
Delegate McComas and the Vice Chair.
Thank you, Mr. Chair. I still have rather global concerns about this because I think there are a lot of people that didn't get the memo from their municipalities or their counties about some of these licenses and tests. And, ignorance of the law is no defense. But on the other hand, we're going to be hurting people that need that extra income, and they're going to be seniors, or they're going to be, folks that need that income that are not that well off. And I think that what we should be looking for is we should be encouraging a campaign for people to come into compliance instead of hurting them on the back end. And a lot of people have been harmed by COVID as renters or as landlords, because those folks have stayed and some of them haven't paid any rent, and they've been unable to get them out for various reasons. So I sort of look at this bill as a taking, and it's subtle, but it's a potential taking of people's rights to their own property. So I just think that it's not ready for prime time, and I'm not going to be voting for it. So.
All right, the Vice Chair.
Thank you, Mr. Chair. I'm really trying to turn Delegate Cardin's line of questioning around in my head and trying to really understand what's going on here. And this is sort of what I think is going on for me, at least, that makes me a little bit more comfortable with it. It's that, sure, you're impairing the landlord's, there's a landlord has a legitimate issue in that they're without proper license. So they ought not be renting theoretically in the first place while that problem exists. Fine. And so now you have a situation where the tenant is the cause of this being raised as an issue. Now, as I understand it, though, as to the other tenants, which is Delegate Cardin's concern, I don't think anything is going to stop the landlord from still collecting rent from the other tenants. All that's being stopped is their eviction. So in that sense, it sure seems to me like it's protecting them while there's a cloud on the entire rental situation to begin with. Again, nothing stopping rent from being collected or due while that cloud is happening. Now, as to whether there's a taking or a harm to the landlord, again, it seems to me part of the theory here is that, well, you're not really taking anything from the landlord in the sense that they can't get rid of this one tenant or these many tenants because under law, they're not entitled to be renting these to someone different. So if the person in front of them isn't paying, so what? They're not supposed to be renting this thing until they get a license anyway. So any replacement value theoretically, you're shaking your head, Delegate Cardin. I'm just saying this is policy wise. This is how I'm a little less uncomfortable with it on the basis that they ought not be renting. So what's being deprived of them is not something that they're entitled to until they get rid of the cloud.
All right, this is what I'm going to do. We'll set this aside until tomorrow. We'll come back and deal with the voting session on this bill tomorrow. And I think we still have plenty of time to get this done. We'll try to address any other questions that are there. I think that I think that the vice chair is right in his assessment here, but we'll make sure that we've got the I's dotted and T's crossed, and we'll go from there. So we'll hold off on Senate Bill 563 and House Bill 703 for right now. We will come back to them tomorrow. But we've got now held from yesterday, House Bill 1448. And there were questions with regard to, I think Delegate Bartlett asked the question as to where the appeal goes in these cases. This has to do with with ordinances and giving district court concurrent jurisdiction with the agencies that adjudicate the sort of the front end of cases regarding the violations of local ordinances. So it's meant with a very narrow intent, and it's just meant to preserve the ability of counties to adjudicate civil fines while still providing a way forward for people to go to district court. If they appeal, my understanding is if somebody wants to appeal, since this would be concurrent jurisdiction, Delegate Bartlett, I think they would appeal to circuit court. Unless they had some other mechanism in that local jurisdiction that would allow them to appeal to district court, and they may have that. That's at least my reading of it. But with that, I'll just see if anybody else has. Delegate Bartlett, do you have any questions?
Well, I just wanted to make a kind of comment. I was just on the phone with Mako trying to make sure I understood 1448. And one thing that I want to make sure of is, and I know this is meant for the Angel case, but I'm only thinking about the Ocean City case because that's the one I'm most familiar with. And I just don't want a situation where there is a local ordinance violation that leads to a charge of failure to obey a police officer that later also leads to, ultimately leads to resisting arrest, which is exactly what happened in Ocean City. I don't want that to, I don't want this 1448 to do anything to hinder that defendant. I think my understanding is that what would happen is that the defendant would be charged with the local ordinance violation in the, at the mayor or city council, and then the defendant would also be charged in the district court with the right to waive, to ask for jury trial in circuit court. I think, or maybe skip district court altogether, although they did start in district court, now I think about it.
No, the criminal cases would start in district court for something like you've described in Ocean City with the failure to obey or the resisting arrest. That generally speaking, unless they were indicted, which I would think would be incredibly, well, maybe not impossible, but rare. Those would start in district court and go forward. This legislation seeks to just address local ordinances and fines related to those local ordinances, and it just ensures that if they have a local adjudication process, that they can just continue with that independent of having to send everything to district court.
Okay, so I think what would have happened in the situation of Ocean City, if 1448 were in effect, then the defendant could have kind of bifurcated, handled his ordinance issue, right? And then gone with the criminal penalties in district court, later getting a jury trial into circuit court.
They could, but I think the point here is that as opposed to having two separate contacts, I think that, again, what this would allow, and what I think the law already, at least in theory, what the view of the law is that all of those would be put together. They wouldn't necessarily be separate under those. There could be a disadvantage in having each one of those cases heard separately. And so it's not unusual for these ordinance cases to be wrapped into whatever district court criminal issue is already out there. So again, this is just providing that concurrent. It's not really meant that, I guess that's not entirely true, but it's mostly focusing narrowly on, so you had parking.
Oh, what about the dog not picking up after your dog?
Not picking up after your dog, smoking at a park in Baltimore City, things like that. Very, very specific things that are just handled by ordinance in those specific areas.
Okay, I accept that, but I just want to make sure I understand this part, and that is, would the defendant have the ability, and I think you said this yesterday, the defendant has the ability to make that choice? Is it the defendant's choice? And I say that because still I'm thinking about Ocean City. In that situation, having an ordinance hanging out, having a violation of an ordinance simultaneously with the criminal charges, is that a defendant call, or is that going to be the mayor and municipality's call?
That would be the municipality's call to bring all of those together, because the two criminal charges are ones that couldn't be handled outside of district court. Those had to be handled in district court. So you'd be bringing the ordinance violation in with the district court. And so also, furthermore, what that would do is, if those district court criminal charges attached to a jury trial right, they would be able to take the whole package up to circuit court if they wanted to go forward and get a circuit trial right. My brain just stopped as to I think that on disorderly conduct, I'm trying to remember whether that's a jury trial right or not, but because whether it's over 90 days or not, but I'm not sure that it is. But in any case, if it were something connected to that, it could all be brought all the way up to circuit court to handle at that level. But again, I think the goal here is the cases that don't include a criminal case can be left in the local. Yeah.
Right, and I understand that, and I can appreciate that. I just don't want, because that situation, we only heard about it because it had the criminal charges and et cetera. But I don't want it to get hidden and on the municipality level, but it wouldn't because it did have criminal charges. Okay.
No, exactly right. Because it had criminal charges, it went into district court. Yes.
Okay. All right.
Yeah.
Thank you.
Delegate Davis.
Thank you, Mr. Chair. I have some similar questions. Yeah, I've been lawyering up on this thing. I've got some issues. So as far as fines, there are civil and criminal fines allowed, right?
I mean, it depends on the ordinance. If there's I'm trying to think of whether there would be a criminal fine that wasn't associated with some other criminal penalty, but
yeah, like smoking cannabis in public. That's something that we dealt with.
That's explicitly a civil fine, but okay.
Okay, you're right. I read the court case, and the summary says that they have the authority to enforce such laws by civil or criminal fines. So criminal fines are available too. So I guess I asked a question I knew the answer to. And the case involves fines of $700,000. And the right of the person to appeal to court. Isn't the question really about your right to appeal a decision made by the administrative agency?
I think that if it were a question solely about that, it actually got its way all the way up to the Court of Appeals. So I'm not sure that they had difficulty appealing the decision at issue in the case in Talbot County.
Yeah, and the court ruled that was the issue, that because they were, I'll read it, that because that their sole remedy was to go to an appellate process by the agency, that was the problem. Civil penalties subject only to administrative review by a board of appeals were facially invalid and unenforceable. That's what it seems like to me.
It's what seems like, I'm sorry, say that again.
It seems like the problem was that there was no place to appeal to on a $700,000 case, that you had to keep it within the administrative agency, and that was the problem.
But I think as I can pull out, I can go and grab the rules. I think that the decisions of an administrative agency, which would be happening here, are reviewable from 7401 to 403 of the rules, of the Maryland rules. So I think there is that process to have those decisions of the administrative agency reviewable by a state court.
Okay.
I mean, if there are questions, and if you want a little more time to talk, we've held another one. We can hold this one just a step longer. If you want to talk to Mako to see if they can address your concerns, I'm happy to do that. It's fine.
I'd love to talk to our counsel. I'd love to just, yeah.
Okay, that's fine. Then we'll hold the train. We'll stop the train on this one too, and we'll come back to this one tomorrow. But with this one and the other two, we're definitely going to do something one way or the other with them tomorrow.
I appreciate it.
Yep, no problem. Look, it's both arcane and incredibly important all at the same time, and I think that we should try and make sure we get it right. Okay, so we're going to stop right there. We will be back tomorrow with another voting session. We have, I think, the last of our bill hearings tomorrow on the 6th of April. And hopefully at 1 o'clock, but we'll find out. And then we will have another voting session tomorrow. Could be a few more things on it than today. But with that, that concludes the voting session for the House Judiciary Committee. Delegate Bartlett, did you have a question?
I do, but
Okay.
you're going to kill me for asking this question. I'm going to ask though, and ask for forgiveness later. My anniversary is tomorrow. And I have a 7
Members
o'clock.
of the committee, we will be
Happy
joining Delegate
anniversary.
Bartlett for her anniversary tomorrow at what will otherwise be a wonderfully romantic dinner. I'm not sure where they're having it, but she's going to let us know. It's now a public meeting, so
You're
I'll be
all
there.
welcome.
I'll be there.
You're all welcome. No, I just want, we have a 7 o'clock reservation, I think. Do you think we'll make that?
I think I think tomorrow is probably going to be like today, and that we should be done about now. But now that I've said that, we'll see if, everything collapses. So
And I've jinxed
it's
it.
fine.
Thank you.
Don't totally jinx it, but yeah, we'll do the best we can. Okay.
Okay.
Thank you all very much. That concludes the voting session for the House Judiciary Committee. Thanks.